meeting to order.
Hi.
I think you can meet.
The host can mute.
Yeah, you can mute that. You have to just scroll up to their photo.
Hello?
Can she hear us?
Can you hear me, Mrs. Mingo?
I think you're on mute right now.
Yeah.
Can you hear me?
I can now.
Okay, how are you doing? How are you doing?
I'm doing great.
Okay, we're about to start the meeting. Do you mind muting your device?
You're gonna mute my device, you said?
No, I was asking you if you wouldn't mind muting it. We're going to start the meeting, and then we'll give you an opportunity to speak later in the meeting.
Okay, I'm just pulling up home. I'm going to transfer from my phone to my laptop and get into a quieter area. Can I hang up and then
Yeah, yes, that's fine. As long as if you can mute yourself. But that's fine.
Okay. So as soon as I log in, I'm gonna isolate myself.
Okay, that's fine.
Thank you.
Thank you. Can we do a roll call?
Call to order.
Yeah, I called the meeting to order at 5:30. And now we'll have the roll call.
Remind us how that goes.
Do you want me to take it?
You took it last time, didn't you?
No, you
I did.
Or you take it?
We could just go around the table clockwise with the members and state your name. You want to start, Jonathan?
Yep. Jonathan Stevens, Vice Chair.
Tyler Mayo, Fry, member.
Christina Palacio.
To Glenn Forbes.
Okay, now we'll do B, adoption of the agenda.
I make a motion to adopt the agenda.
Second.
All opposed? All in favor?
Aye.
And then we'll do C, approval of the minutes.
I make a motion to approve the minutes.
Second.
All in favor?
Aye.
All opposed? Right, we approve the minutes.
Okay. So there's no old business. We'll do E, business discussion item. This is Janika Mingo versus Park Meadows Health and Rehabilitation Center. This is EO-E-2022-19.
Do you want to wait for the complaint?
Yeah. So far, so good.
Well, good, there's not much left. Not much left to go wrong. We would hope.
There's plenty.
Don't go jinxing it, right?
City commission,
City commission's tomorrow meeting, so.
that sounds like fun.
How's your Wednesday then?
It's been okay, it's better than yesterday.
Yeah, what happened yesterday?
Nothing good,
Fair enough.
nothing to go on the record. Do you sit in on the committee meetings?
No, I typically do not unless there's a labor and employment issue or I'm sitting in for the city attorney.
I bet Dan wishes he's had any more.
Oh, yes, he loves going to meetings.
Go ahead and get started.
Thank you.
Chair, the Equity and Inclusion Office has provided the members of the Human Rights Board a written report concerning complaint of discrimination EO-E 2022-19. We have processed the complaint as required by Chapter 8 of the city's code. We are here today to report our findings as to whether reasonable cause exists to believe that an unlawful discriminatory practice has occurred in accordance with the City of Gainesville Code of Ordinance, Section 8-48, subsection A, subsection 1. We are now ready to report the results of our findings concerning complaint of discrimination EO-E 2022-19.
Members of the board, thank you for your presence and participation. You have each received a copy of the final investigative report for complaint EO-E 2022-19 and have had time to review the findings. I will now summarize the findings as it relates to this case. The complainant began her employment with respondent on June 19, 2021 as a wound care supervisor. On or about February 21st, 2022, complainant was issued 2 notices. One notice was due to excessive tardiness and the other was for a complaint made by an individual from a corporate office. Complainant stated the second disciplinary action concerning a corporate complaint was blatantly false. Complainant stated Mr. Latson accused her of arguing with Mr. Willie Ivy, blackmail, LPN, while a state surveyor was present. Complainant stated Mr. Latson told staff that he was going to, quote, lighten up the building, end quote, before her termination. Mr. Latson pointed to a white unit manager while making this comment and said he was going to hire more people like the white unit manager. Following complainant's termination, complainant was transferred to the villages. Complainant stated respondent disciplined, demoted, and terminated her based on race, black, gender, female, and her association with a person with a disability. Respondent's position. Respondent denies all complaint of discrimination against complainant based on race, gender, and disability. Respondent stated complainant was hired on June 19, 2021 and held the position of LPN supervisor, wound care. The complainant never served as a unit manager. She was not responsible for a unit and the related supervisor of facility staff. The decision to discipline complainant was based on legitimate, non-discriminatory business reasons consistent with company policies and procedures. The complainant voluntarily resigned from her employment. She was not terminated nor transferred to a sister facility in the villages. Respondent stated there is no nexus between complainant's complaint of discrimination based on her race and or association with a person who has a disability and has discipline and job separation from Park Meadows. On February 16, 2022, complainant was issued a disciplinary write-up for offensive and disruptive behavior in the workplace. On February 21st, 2022, complainant was issued disciplinary write-ups for excessive tardiness. Respondent denied that Mr. Lesson made the statement attributed to him that he was going to lighten up the building. Respondent stated that Mrs. Trishana Daniel, black female, LPN supervisor, wound care, replaced complainant. Summary of investigative findings. To establish a prima facie case for race and gender discrimination, complainant must show 1. Complainant is a member of a protected class. 2. Complainant was performing at the satisfactory level. 3. Complainant was discharged or otherwise disciplined. And 4. Complainant was replaced by an employee outside the protected class. The complainant is a member of multiple protected classes based on her race, black, and gender, female. Therefore, the first element was met. Regarding the second element, witnesses stated that the complainant engaged in a verbal altercation with Mr. Ivy. Specifically, on February 21st, 2022, complainant was issued a notice of disciplinary action for, quote, unprofessional behavior unbecoming of a nurse supervisor behavior that is offensive and disruptive in the workplace, close quote. The complainant refused to sign this disciplinary notice regarding an altercation with Mr. Ivy. However, in a statement, Ebony Williams, the Director of Nursing, DON, stated that the complainant was brought into the office to address this incident, which occurred on February 16, 2022. Williams stated that the complainant became belligerent, close quote, saying that she resigned effective immediately. Also, on February 21st, 2022, the complainant signed and acknowledged excessive tardiness on February 1st, 7, 14, 15, 16, and February 21st, 2022. Other witnesses, such as Ashley Trinidad Payne, staffing coordinator, stated that the complainant could agree with the time and attendance write-up and sign off, close quote. However, the complainant did not agree with the workplace misconduct and refused to sign it. According to Trinidad Payne, at the time, the Director of Nursing, James Lasson, was explaining to her the reasoning behind the write-ups. The complainant became irate and walked out. In its defense, respondent articulated that the adverse action against the complainant was based on legitimate non-discriminatory reasons. Specifically, current and former employees of different races and gender were interviewed. While some of the witnesses attested to complainant's satisfactory work performance, others stated that she left work early during the week of the annual survey, even though management members were asked to arrive early each day and not to leave until the survey was completed. These witnesses stated that complainant was late to work and engaged in a verbal altercation when she became, quote, belligerent, close quote, and argumentative, close quote. Complainant agreed with respondent's assessment of the time. Complainant agreed with the respondent assessment of the time and attendance write-up and signed the notice. But complainant did not agree with the workplace misconduct and she refused to sign the disciplinary notice. Ms. Williams stated in a statement that while the supervisor was explaining the reasoning behind the misconduct, complainant became argumentative, gathered her belongings, and quit her job. At the time of complainant's complainant's employment. Respondent employed male and female employees of different races and gender. Also, many employees either quit, resigned, or were terminated for various reasons between March 2021 through March 2022. Ms. Treshana Daniels, black female, wound care coordinator, who was hired on May 13, 2022, replaced the complainant. There is no evidence an LPN supervisor wound care was hired to replace the complainant. In addition, complainant has not demonstrated that the respondent's articulated reasons for the adverse action was a pretext for prohibited discrimination. Therefore, the second element was not met. The analysis ends. Therefore, based on the totality of evidence or lack thereof, there is no reasonable cause to believe the respondent violated the City of Gainesville Code of Ordinance, Section 8-48, subsection A, subsection 1. Disability. To establish a prima facie case of discrimination based on disability, the investigation must show the following. The complainant is a member of protected class. Complainant was performing at a satisfactory level and meeting the respondent's expectation. 3, complainant experienced an adverse action. And 4, the respondent treated others outside complainant's protected class more favorable, or evidence exists demonstrating that the adverse action was based on the complainant's protected class, or complainant was replaced by an employee outside our protected class. Regarding the first element, complainant stated she is associated with a person with disability. Respondent was aware of this association as complainant disclosed this information to various staff during the hiring process. Therefore, it can be argued that the first element was met. Regarding the second element, witnesses stated that complainant engaged in a verbal altercation, violated company policy, was repeatedly tardy, and quit. Therefore, the second element was not met, as complainant was not performing at a satisfactory level and meeting the company's expectation. Therefore, based on the foregoing, there is no reasonable cause to believe the respondent violated the City of Gainesville Code of Ordinances, Section 8-48, subsection A, subsection 1.
As indicated in the written report, we have determined that there is not sufficient information that will lead an impartial observer to believe that a discriminatory practice has occurred. If you do not believe that there is reasonable cause to believe that a discriminatory practice has occurred, the Equal Opportunity Director must dismiss the complaint. You also have the discretion to, by a 3/4 majority vote, order such further investigation as deemed necessary. Your decision should be based on the evidence of record. Chair, as required, we have provided the board with evidence concerning our investigation of complaint of discrimination EO-E 2022-19. You must now decide based on that investigation.
Members of the board, you have had the
Excuse me.
I'm sorry.
Will it be possible for me to read the supplemental before the voting?
Sure.
That's it.
I was gonna ask about it.
Yeah.
Supplemental to the initial investigative report. This revised investigative report was initiated because the complainant disagreed with the initial recommendation of the final investigative report. The initial final investigative report was issued on July 7, 2023 during the follow-up investigation. The complainant resubmitted the same evidence submitted during the initial investigation phase. The complainant argued that management approved her absences. The complainant also stated the absences should not have been counted against her. The complainant claimed she did not engage in inappropriate conduct or resign. Instead, she was terminated. Also in her charge, the complainant reiterated that Mr. Letson, black, wanted to lighten up the building. The complainant stated that when asked what Letson meant, he pointed to a white unit manager and said, quote, "I am going to hire more people like you," close quote. The complainant also stated that her role was given to a white female before termination. The complainant did not identify the white employee who replaced her. During the investigation, Clara Key was re-interviewed regarding the specific allegation of, quote, "lighting up the building," close quote, attributed to Letson and the assertion of whether or not the complainant was terminated. During the second interview, Kay was asked about the specific allegation of lighting up the building attributed to Mr. Letson. Kay stated that she was present and heard Letson make this statement. Kay stated that the complainant was terminated, but she was not present when the termination occurred, nor provided evidence to support a statement that the complainant was terminated. Kay also stated that Letson or Ebony asked the complainant to hand over her keys, quote, close quote. Kay stated she was present when the complainant was instructed to hand over her keys. However, Kay was not in the office nor present when the complainant was reportedly terminated. Kay also stated the senior Matheron, Vice President of Operation Black, asked the complainant to transfer to the club in the villages after her employment at Park Meadows. In addition, Kay was not present when Matheron asked the complainant to transfer to the villages. According to Kay, the complainant called and told Kay that she, the complainant, had been transferred to the villages. In addition, the complainant called and inquired whether Kay had heard of the club in the villages. Kay stated that April Brown, Black, Ebony Williams, Assistant Director of Nursing, and Ruth, last name unknown, Mr. Terry Harris, HR Payroll Specialist, Black, and Christina Loranger, white, witnessed the comment. Ebony Williams and Christian Loranger were interviewed during the initial investigation process. William denied Letson made the comment in the statement attributed to Letson, nor the claim that the complainant was terminated. However, in a recent statement, William stated that the complainant was, quote, belligerent, and Willie Ivy was suspended for 3 work days because of the incident, the argument. William also stated, and I quote, as the disciplinary action was presented to the employee complainant, she stated that she resigned effective immediately. The respondent left keys and left the building at the time, close quote. Ms. Loranger was a reluctant witness who insisted on gathering contact information from the investigator before providing information regarding the allegation. The requested information was provided to Loranger. Even though the requested information was provided, Loranger still refused to be interviewed. Mr. Harris was also interviewed regarding the allegation. Mr. Harris left the company in February 2022, so he could not say whether the complainant was terminated. In addition, Mr. Harris has no knowledge of, quote, lighting up the building comment statement attributed to Mr. Letson. April Brown and Ruth were not among the initial witnesses, and there was no contact information available. Lieutenant Matheron was interviewed regarding the allegation that complainant was terminated and Letson wanted to lighten up the building. Matheron has no first-hand knowledge of whether the complainant resigned or was terminated. However, Matheron was informed that the complainant probably walked out after being reprimanded. Matheron also stated that Park Meadows did not transfer the complainant, but she knew the complainant was upset after what had happened. Mathurin also stated that her employment at Park Meadows Mathurin also stated after her employment at Park Meadows, the complainant contacted her and inquired about a job. Mathurin stated she called her director and informed her that the complainant, quote, needed a paycheck, close quote. So Mathurin volunteered and suggested sending the complainant to 3 different properties, 3 different job sites in Gainesville for jobs. Mathurin stated that the complainant said no, quote, close quote, to her suggestions. Mathurin also stated that she never heard the lightening up comment and Lesson never made such comment in her presence. Ashley Trinidad Penn, Black Staffing Coordinator, CNN, stated during the initial interview that she was present when the complainant received her write-up. Trinidad Penn stated that the complainant had 2 write-ups, one for attendance and the second write-up for workplace misconduct. Trinidad Penn stated that the complainant agreed with the first write-up and signed the notice, but she did not agree with the workplace misconduct and she refused to sign it. Trinidad Penn stated Letson informed the complainant that she could work as a la carte nurse to accommodate her time and attendance. Trinidad Penn also stated the complainant refused. According to Trinidad Penn, the complainant did not agree with the misconduct and became argumentative. Trinidad Penn added that while Letson was explaining to the complainant the reasoning behind the misconduct, the complainant became irate and stated that she was leaving and never coming back. Trinidad Penn stated complainant left her keys on the table, walked out of the office and gathered her belongings. Trinidad Penn stated that the complainant walked out of the building and did not return. In the defense, respondent denied the statement that Letson wanted to lighten up the building. Assuming this statement attributed to Letson is true, this alone does not support claims of discrimination, and there is no evidence to prove that the complainant was terminated because of her race or gender. Respondent also stated that the complainant acknowledged and signed the employee notice regarding tardiness. In addition, the complainant was not terminated. Instead, she quit. Respondent stated that Tanisha Daniels, Black female, Wound Care Coordinator, who was hired on May 13, 2022, replaced the complainant. Therefore, based on the totality of evidence and several interviews, there is no evidence to change the initial recommendation of no cause violation based on race, gender, or disability.
So as indicated in the written reports, we have determined that there is not sufficient information that would lead an impartial observer to believe that a discriminatory practice has occurred. If you do not believe that there is reasonable cause to believe that a discriminatory practice has occurred, the Equal Opportunity Director must dismiss the complaint. You also have the discretion to, by a 3/4 majority vote, order such further investigation as deemed necessary. Your decision should be based on the evidence of record. Chair, as required, we have provided the board with evidence concerning our investigation of complaint of discrimination E-2022-19. You must now decide based on that investigation.
Members of the board, you have had the opportunity to read the investigative report concerning complaint of discrimination EO-E-2022-19 and heard the summary of that report provided by the compliance investigator. What questions, if any, do you have concerning the report? Any questions from board members should be directed to the chair.
Dear Chair. I have a question. I guess was there any evidence of the approval for, because
just there,
Time
keeps
off.
doing the approval for time off, even though I recognize that the complainant actually signed the
Attendance.
attendance issue and the report on it, but is there any evidence that there was some approval for her to?
I don't have such evidence.
There was no, okay. Because that was repeated several times. And also just one brief question on the Matherin stated that she was informed the complainant probably walked out after being reprimanded. Do we know what that means? By whom was she?
Some of the employees informed her.
So somebody else had contacted her and said that she had probably walked out. Okay, she had no first-hand knowledge herself, so everything she was hearing was either from the complainant or other people on the job.
And there were several other employees who were present. And for example, Williams, who was present, the DON.
Yes, and she said that she walked out. Okay.
And Trinidad Penn.
And Trinidad. All right. But no evidence of that approval of her absences because of
The complainant did not provide that information.
I have a question about the supplemental report. It's my understanding that Kay seems to be the only witness corroborating the complainant's allegations, and every other witness seems to fly in the face of those allegations. But Kay was not present, is that correct?
Kay was not present during the alleged termination.
But she was present during the comment about lighting up.
She said she was present. That's what she said.
Okay.
Okay. Another question, do we understand why, I think by my count, two witnesses were unwilling to cooperate with the investigation?
The name is Loringer. Complainant had about 10 witnesses on our interview. About 9 of those, almost all of those witnesses. Loringer, that's the one, she asked for my contact information and so on. I provided that information, but she didn't want to be interviewed. She didn't want to provide additional information. And also
Mr. Ivy.
Mr. Ivy, yeah. Mr. Ivy, the person that the complainant was involved in the alleged altercation.
The one who also received the 3-day suspension.
That's correct.
One question. What's the documentation from the Human Resources Department have for the termination? Was it just the transfer and then they say that it was job abandonment or resignation?
The company did not terminate the complainant. They said she quit.
quit.
Yeah.
Okay.
And there was no transfer documented, correct? There was no official transfer from their end that they transferred her to another facility?
No.
Okay. Thank you.
That raises another question for me. The transfer to the villages was a demotion and a 1.5-hour drive.
That's the allegation she's making.
So complainant stated as a result she did not continue working at the location in the villages, which infers that for a time she did work at the location in the villages. Is there any evidence that she had a shift at the villages?
I don't have such a record. The respondent says that it doesn't make any sense to transfer somebody to the villages if you already quit.
So that's what they're saying, but there's no evidence of a clocked shift at the villages.
I have no such, no sir.
Did you look for it? Just asking.
I mean, the company said that they did not transfer her, so they don't have any record working at the villages.
Do we have any other questions, board?
There was one other, I guess, reference to somebody having actually made a report of her coming in late on the days that the state was there doing their survey. Let's see if I can
3, that second full paragraph.
See this one?
Statement by all the supervisors.
February 1st, 7th, 14th, 15th, 16th. Those dates.
Yeah, well, on the dates that, no, not all of those dates
So
were the
during-
state there,
So
except
during
during
the week of
state, right.
14th.
And then on, somewhere I saw that it said that the state, that somebody actually made a record of her coming in late on that day and reported it to someone, and I thought I highlighted it apparently.
Yeah, so right here. The first paragraph. Complainant was regularly scheduled to work from 8 to 4:30, was tardy and left work before the end of the regularly scheduled hours, multiple days throughout the survey. Rebecca Mons, who's assisting the facility during the survey, witnessed these violations, leaving the facility for lunch and before the survey team left. So Ms. Lucina Mathera reported the incident to management.
That's it, yes, thank you. I was looking at the wrong report, yeah. And so we did, that was reported by Matherin, and she, okay, he has also stated it. And so you had confirmed that, we just consider that confirmed, and she actually reported that to management during that
What's the
time.
question again?
She reported to management, was there a written report of her being late during those times? I guess that's what I was asking. Because it seemed to indicate that there was a report of some kind of her coming in late on the days of the survey.
I think,
Yeah,
sorry.
I believe that's Ms. Mont. I also have a statement from Ashley Payne and Ebony Williams.
Okay, and they all said yes. she can-
Yes, ma'am.
Also, the tardiness slip that she signed, right? So the survey was the week of 14th, so 14th, 15th, 16th would have been included in that.
It wasn't included, yes. Okay.
I have the tardiness report here.
Oh, okay, so you have, there was an actual tardiness report that was.
I did the
Okay,
tardiness
that
report.
was what I was wondering, thank you.
Any more questions from the board members?
One last question from me. At the very end of the supplemental investigation, there's a statement that says that Trinidad Payne offered a la carte nurse to be able to accommodate her time and attendance needs. Do we have any record from the Human Resources Office that there is an actual offer that was made?
I don't have that report. Okay.
You're talking about the avocado.
Yeah, it'd be like an OPS position for them. Like, she couldn't just offer that if she didn't have some kind of job offer for it, or something in place for that.
That's a recent statement from Trinidad Payne
Right.
regarding what Letson said.
Because she was the coordinator, the staffing coordinator.
She put it in that statement, you know.
Right.
All right, now I'd like to offer the parties of interest, privileges of the floor. Would the complainant like to speak? Can they hear me?
I think we're on me right now.
These should be working.
We
This is
have green
in-
lights on.
Okay. I think you repeated. The mics are on.
The mics are on?
You can turn it on.
She's muted.
She's muted.
Hi, Ms. Mingo.
Hi.
Would you like to speak?
Yes, I sure would. Can everyone hear me?
Yes,
Yes, ma'am.
we're gonna set a timer for 3 minutes, and then we're gonna give the same amount of time to the respondent.
Hello, can everyone hear me okay?
Yes, ma'am. All right.
Can you
You're
hear
on me,
us?
right? You're on me.
Can you hear us?
We can hear you.
We can hear you, ma'am. You can begin in, you can whenever you're ready.
Okay, no one answered.
Uh,
So I
Wait,
don't
wait,
know
wait,
who
wait.
I'm speaking
Sorry,
with,
one
but
second,
my
Ms.
name is
Mingo.
Jonica.
Wait, excuse me 1 second. When that's on mute, can they not hear us?
No, they don't.
Apparently not.
These, so they've been sitting there,
I didn't realize that
She was muted.
No,
We
no,
were
not,
muted.
not her,
We were
we were muted.
No, our audio's there. But it's not going to the Zoom is the thing, because every time I see
Okay,
the two.
okay, so we're getting the remote too.
Mhm.
Okay.
Is there a way for us to turn on the mics on that computer perhaps, so that there's not the reverb? Because I think that's like there are no mics on that. There are no mics on that computer.
It's between this and that one.
Yeah, that's the reverb.
Interesting.
All right, so while we were apparently muted, we went over the investigative report and this supplemental to the initial investigative report. So now we're opening the floor. We also, the board discussed some questions amongst ourselves, and now we are opening the floor to interested parties. So complainant
You
will
all were on mute. I don't know if I was supposed to hear anything, but I did not hear anything.
You were supposed to hear us read the findings of the investigative report and the supplemental investigative report, which are two things that you've already read. We were reading them ourselves. So now we're going to give some time to the complainant, 3 minutes, and then we're going to give time to the respondent, 3 minutes. So Ms. Mingo, the floor is yours.
Okay, so first off, I want to say how extremely disappointed I am with how the whole situation has been handled. Basically, throughout this entire investigation, multiple lies were blatantly told repeatedly by Park Meadows. The city in itself lacks the skills to investigate, urgency, professionalism, and compassion. The administration of Park Meadows Health and Rehabilitation allowed the former DON, James Lackton, falsely accused me of getting into an altercation with another employee without thoroughly looking into the details. It was this write-up that led to me being demoted. In the same setting, I was written up for approved absences related to my disabled child's health. Doctor's excuses were provided. As an innocent nurse, a mother, my disabled son and myself, we're all victims. Basically, as in the entire investigation, I was hired on June of 2021. I was hired on by a DON named Tamara. I explained my situation thoroughly. And when I explained my situation, I told her about my disabled child. I told the HR upon onboarding about my disabled child and my situation. They knew I was coming from New Orleans, Louisiana, and I was moving into Florida by myself. So the company knew about my disabled child. In December, fast forward, in December of 2021, my child's father filed an ex parte order, falsely filed an ex parte order, and took my child from me. So that opened up a full custody battle. I did not open that up, he did. So I had to comply with those orders. At that time, a DON by the name of Cynthia was there, and Ebony Williams was there, and I told and informed her about the situation. There was an app called WhatsApp that I provided to the city, screenshots, several screenshots of all of those messages, where verifying that we communicated about this constantly. His doctor's appointments, his OT, ST, and PT that was vital to my custody case, being able to keep my child in my presence. The company decided to call me in for a meeting,
Ms. Mingo?
write me up, stated that they were not accepting
Mingo?
my write-ups. I had
Ms. Mingo?
nothing I could do about it. I acknowledge that I signed those write-ups. I was about to get up out of my seat.
Ms. Mingo?
And it
So
Yeah, so you went past that 3 minute mark. time to speak.
Okay.
Yeah,
Is there a motion to extend the time?
I would give her, I would make that motion.
Second.
All in favor?
well, point of information, what time, how much extra time we get?
1 minute.
1 minute? Okay, that's fine.
All right, so Ms. Mingo, you have 1 additional minute, and then the respondent will also receive 4 minutes.
Wait, Ms. Mingo?
Entire
Just let her-
investigation
just let her-
has not been done properly, and again, I think if they thoroughly look at everything, Park Meadows has blatantly lied several times, and it's proven. Very well documented on my end.
All right, thank you. And now can we get 4 minutes for the respondent's party?
Thank you. Jonathan Levittan, I'm the authorized representative of the facility, Park Meadows. I've reviewed both your initial findings and your supplemental findings, and they're in concert with the facility's view of the case, that there's no evidence to substantiate the claims, which are also expressed in our position statement. We've got nothing further to add, except to say that we accept the findings and the conclusions.
All right, thank you.
Thank you.
Could both respondent and complainant mute themselves again to help out with our reverb issues?
Are we allowed to open up a question about it?
Yes.
Okay, awesome.
Oh, just wait. Can they hear me? Can the respondent and the complainant please mute themselves again, please?
I'm sorry, I have difficulty hearing you.
Can you all mute yourself again?
No, I'm sorry, can we all do what?
Put yourself on mute.
Oh, sure.
Jonathan,
Can
your
they
question.
hear us at this point? Are we sure?
Can you all hear us?
Now they're muted, but they should hear us.
Yes.
Okay, Jonathan, what was your question?
Yeah, so
Can you mute this computer?
No, then they can't hear
No,
us.
not mute Zoom, but mute the computer so that we don't hear it.
So with these WhatsApp messages that were obviously transpired, I don't know if this was discussed in the supplemental or the initial report, but I guess my question to, I guess, for the chair, or in my procedure is kind of where, was this discussed and like, was this something that was, I guess, excused in a way? Like obviously there was reprimand that was, I guess, delivered through a notice and it was signed on. But, I mean, was this discussed more so as trying to be flexible with this person? Because I'm just a little confused about just like,
I mean, I'm sorry, what's this?
the absences situation. Because I feel like that's a big element for all of this is the satisfactory performance. And obviously, we're calculating that the fact that she missed a lot of her shifts, or that she was late to some of her shifts, or she had a tardiness, that calculated as, you know, not having satisfactory performance. So I'm trying to understand, like, was this something, like, what were these WhatsApp messages that were alleged by the complainant? Were those received by the office? Were those processed by the office? How were they?
There are a lot of WhatsApp messages that complainants submitted. Most of this were unrelated to this. They talk about, oh, how's your child doing? My child is going to have surgery today, or I hope everything is going well with you. Those are interchange between different employees and the complainant. The core of these tardiness happened when the state inspector, the management sent, notified the supervisor that you have to be here when the inspection is conducted. And, you know, they were well aware of. But during this time, complainant did not make this
If we're
request.
supposed to be able to hear you, we can't hear anything you all are saying.
Yeah,
Well,
We
but
apologize, Ms. Go ahead.
I was gonna say, but even then, it's way over here, so they wouldn't really hear innocence. We need these to work.
But this doesn't work.
Can you go to recess to see if we can get these fixed? The lights are, I mean, if y'all please.
I can come over there.
or we can just move the mic closer to her. Can you hear us now?
Maybe if you hold it.
It doesn't look like she's hearing.
Innocent, do you want to speak into that?
They're not hearing.
Lights are green, they're charged.
They're charged, but they're
Can you
still.
hear us?
I could hear that last one.
I could hear like the last thing you're saying, like, but it would, everything else you said, it was like, I don't know what you said.
And I could hear you say, can you hear us, but I didn't hear anything before that.
Okay.
And your voice, so I couldn't distinguish what was being
Alright, so
said.
if someone's speaking, we'll just hold the mic there.
So they can hear this. Ms. Mingo, can you hear me right now?
See, I don't think that's
We should run into Zoom here in the future, I think.
so. My question is do you see like
It's muted on now.
it's muted on that one?
Those levels are jumping, those are audio.
But is that for the recording though? Like I'm not trying to like question. I'm just trying to, because I know that like I'm seeing on the screen from the camera, I'm seeing that we're unmuted. But I'm seeing on
That one is on.
that one,
This one is on.
this one is unmuted. Exactly. So I'm saying, is that one unmuted? Is that affecting that?
Hold on.
Can you hear us now? Can you mute yours?
There was some pretty bad feedback there.
Yeah.
But can you hear us now?
Yes.
Okay,
Okay.
alright.
Okay, it's fixed.
Alright, fixed.
Can you hear us also, Miss Mingo?
Yeah, I can hear you.
Yeah, it's just a feedback, like, it's an echo,
Is it a lot clearer now?
Yes, it's better on mine.
much better.
Okay, we apologize about those technical difficulties.
Oh,
Alright. So just to clarify, just make sure, the messages that were submitted into this, like investigative report, didn't have any relation to, I guess, the absences directly. It was just more so just checking in, like,
Yes, I have,
very close.
I have those text message, WhatsApp messages.
Okay. I have no further.
Actually, oh, sorry, go ahead.
Are you asking me that?
Oh, no, sorry, we're asking.
Oh, sorry. Can the respondent and complainant mute themselves again? This is us talking after we gave you the floor.
Could you repeat that, what you'd like me to?
Mute yourself, please.
If you could mute yourself.
Oh, thank you.
Thanks.
We apologize about the.
Apologies for the technical difficulties. So my question was, do we have anything on record or any documentation around FMLA requests, approvals, or anything around the request for those approvals?
No, this has nothing to do with FMLA, no.
Well, intermittent schedule abbreviations or anything
I
like
guess
that?
it would be more the accommodation issue.
Right, if it was an
So,
accommodation for the schedule.
And were they,
No such requests were made officially.
Okay.
and again, so, I'm sorry to beat this dead horse, but the WhatsApp messages were they related to the dates that were
No, ma'am.
written up? Okay, so they weren't related at all to the dates that were.
We
given in
got
the
several
report?
WhatsApp messages from different employees checking on
None.
the child and see how she was doing.
Okay, but none from supervisors who would have been responsible for approving?
No, I don't have such
Time off.
approval,
Okay.
no.
All right, board, I believe we are now ready to vote. I'm reminding that you may only consider the evidence of record. The Equal Opportunity Director has determined that there is not sufficient information that would lead an impartial observer to believe that a discriminatory practice has occurred. You should vote aye if you agree that there is no reasonable cause to believe that a discriminatory practice has occurred. You should vote nay if you believe that further investigation is deemed necessary. The board shall specify the areas of further investigation if, by a 3/4 majority vote, further investigation is deemed necessary.
Sure.
Yes.
I move to move forward with the deliberations in case number EO-E-2022-19 by unanimous consent or I vote.
All right, so you're saying you want to accept the office's recommendation.
Just accept it.
Is there a second?
Second?
All in favor?
Aye.
All opposed? The board has voted that there is no reasonable cause to believe that a discriminatory practice has occurred.
board has voted that there is no reasonable cause to believe. The board has voted that there is no reasonable cause to believe that a discriminatory practice has occurred. The board has determined that there is no reasonable cause to believe that a discriminatory practice has occurred, and I shall dismiss the complaint. This concludes today's business as it relates to complaint of discrimination EO-E 20222-19. We're now to F of the agenda. Any public comment?
So, since you all are voting that it is not a discriminatory act, how do I appeal that? Or is that even possible? Because again, like I said, I still do not agree. I submitted more than enough information, and I don't think that that was thoroughly reviewed. And the 3 minutes that I had, I don't think was enough time to even dispute what I wanted to dispute. It's a lot of stuff that I had that I could fine tooth comb it, and I can't even like say, oh, let me show you this. Like that question he just had and said, oh, well, they didn't relate. They did relate. They absolute dates and times absolutely related. There was no way I could get off unless my supervisor approved it all. So how do I go back and appeal it all? Again, my son has Down syndrome.
No, I mean, Ms. Mingo, there is not an appeals process for the Human Rights Board.
So then someone help me and tell me what's my next step. Because again, I feel like what was done was completely wrong. You have a nurse, a mother, a first responder who has a Down syndrome child, who lost a job, who is struggling till this day. I have to figure out how to pay $8,000 to my RN school that I just completed today. I've been having this hardship since I left Park Meadows. So help me understand, or help me make sense of what to do.
Ms. Mingo,
Here in Florida.
I apologize. We're not here for giving legal advice.
So then what are we here to do then?
We were here to
You know,
hear.
it's not making any sense, and they're wondering why you have such a major nursing shortage when you have companies like this who are allowed to continue to do and carry on in the manner that they're carrying on. That is absolutely absurd. When administrators, when DONs, when ADONs are allowed to continue to do what they're doing, that should not occur. Like that's ridiculous to come up with frivolous lies, and then we got it in black and white, plain in black and white. Like I can't make this up. To say, oh, I never ever transferred you to another facility. Well, how did I get to your sister facility, and how did I get a payroll check? How do I get all of these text messages from Lencina in her cell phone?
Innocence.
I'm sorry, asking me a
Do you
question.
have a payroll check from Ms. Mingo?
It's a bunch of payroll,
The
yes,
villages on it?
payroll checks that I have from the villages, which is Millennium
We can't open
Sister
up
Facility.
the questions at this point. I mean, we have to
From
follow
me
the
being
procedure.
transferred.
So,
I
we
was
just need to go
transferred,
through
and
this.
they're saying I quit. I did not quit. I was escorted out of that
But we did
building.
ask that question before.
I was escorted out of
We
that
were at that
building
part of our
because I
procedure
refused
in
to
this
sign my
hearing.
second write-up.
We're well past that at this point.
I I refused to sign the second write-up. The first write-up was related to my disabled child. The second write-up was related to a completely false lie that was totally made up. Because I refused to sign that, I was escorted out of the building. And I literally texted Lencina Matthews. Lencina, in text messages going back and forth, sent me to the villages. And then she said, I asked her for a job there? I didn't ask her for a job. No, you transferred me over there. You transferred me to the villages. You had your regional nurse Maria to contact me about another job at the other facility. It's another facility. You offered me the job in the villages, and the only reason why I turned it down because it was 2.5 hours away from my son who's disabled and gets sick. I am very passionate about what I do. I even pulled in an HR, a letter from Karen Harris I got, who was the HR director who did the onboarding. Terry Harris was hired. The letter was on letterhead.
Ms. Mingo, your 3 minutes for public
Terry
comment have
Harris
ended.
proving
It's muted.
that he hired me on with the condition that my son was disabled.
That one is.
Ms. Mingo, your 3 minutes for public comment have ended.
Okay,
Thank you.
I appreciate it. Thank you. God bless all y'all souls. It's really good.
Is there any other public comment in the room?
So no other public comment. We have member comments.
I think, and I don't know if this is a bylaws thing or this is a statutory thing, but I think I would be amendable to us increasing the time for some of these complainants and respondents to speak. I think 3 minutes, I know that this is trying to, I guess, mirror the timeline of public comment, but I don't know if it's the most efficient time in these, tribunals to deliberate on some of these matters. So I'd be open to 4 or 5 minutes. I think she took 4 minutes for this matter, but I think for us to make sure that we can get them to at least have enough time to share their case, share their story, and what information they feel like we need to investigate more into, that'd be appropriate.
Yeah, because I think that might have informed more whether or not we had other questions to go back and look at some other documentation.
So is that a bylaws, or is that a?
I'm not sure if it's in the bylaws, but that would ultimately, if it's in our policies and procedures, then it would have to be, Mr. Folston would have to want that to happen, so it's a discussion we'd have to have with him, and then it would have to be approved by the city commission.
Okay,
If it's just the process that we use, then that could be authorized within the OE office itself.
Okay.
So I could go back and see if it's actually in our administrative procedures or if it's actually in like one of our processes.
Okay, awesome. That'd be great.
We
Thank
can
you.
always extend the time by motion. But
That-
that's different than permanently changing and giving everyone 5 or 6 minutes or whatever.
Yeah, I mean, I understand that. I'm of like the stance of like, why not just increase it now? Because I think that, respectfully, in these spaces and in these like legal settings, we don't usually see 3 minutes necessarily be used to explain a case. I know that we're a different kind of tribunal, we're more quasi-judicial than other, boards or courts that would look at these type of cases, but I feel like 4 or 5 minutes is reasonable, and I don't think that it would impede on our ability to handle our business, if that makes sense.
Other member comment, I see we have a new member on the board, so maybe we should be doing introductions today. Should we want to start?
I can do that. Hello, I'm Tyler. Really great to meet everyone. Have a history of the last decade or so in HR, so that's why all the employment stuff just adds up with the documentation questions that I was asking. Really excited to be able to join the board, be able to help out the great city of Gainesville.
Welcome.
Thank you.
Christine, should we also introduce ourselves?
Oh, okay. I'm Christina Palacio, and I'm retired now, but I was an attorney for Shands Healthcare, and so some of these issues came across my desk and within the internal sort of corporate world. And so I find it very interesting, and I'm trying to give back to the community in some way.
Oh, that's awesome.
I took Quinn, chair of this board as of the last meeting, I think. Also looking forward to giving back to Gainesville in this role. PhD in sociology, studied inequality, specifically in higher education for my dissertation. So that's what I'm bringing to the board mostly.
I'm Michelle, I'm the labor and employment attorney for the city of Gainesville.
I'm Susan Kuduale. I'm the compliance manager with the Office of Equity and Inclusion. I've been in this role for a little under a year now.
My name is Jonathan Stevens. I'm a third year now, food science major. Time flies by. Food science major, I minor in ag and natural resource law. I'm really passionate about this area of law, and a lot of it does intersect within the areas of law that I want to, practice in the future. So I'm just happy to be here and happy to be a student representative for students across this city.
That's great. And we're missing Maya. Sorry.
I'm the compliance investigator in the Santa Monica. I've been here for about since 2019. Oh, a long time. Yeah, I'm the compliance investigator for the city of Gainesville Office of Equity and Inclusion, and I enjoy what I do.
And we're missing another student member, Maya, and Joanna, who's a social worker in town. Any other member comment? Oh, I had a question. Any movement on some of the initiatives that Jonathan raised the last meeting?
No, not yet. I want to address those and get back with the board. There's a couple of housekeeping matters I need to address. So moving to the next item, the next meeting date will be October 18th, 2023. At this point, we're at the adjournment stage.
I have a motion. I need to adjourn this meeting.
Second.
All in favor?
Aye.
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 All